Well, welcome everyone. I'd like to just take this moment to introduce our speakers and welcome you all here today. I want to thank you all very much for coming here. We have a lot of great information that we're going to share with you today. Just want to take a moment and introduce myself. My name is Frank Carmon IV. I'm a third-generation funeral director and a member of the Carmon family. I'm here today with my uncle John Carmon, who's one of our speakers, and Jay Kearns III, who is an attorney in West Hartford and who will be sharing some information with you today. Just a few housekeeping things before we get started. Just ask that you hold all of your questions until the end. Both of our speakers will speak. If you have any questions, if you just want to jot them down, and then we'll take your questions at the end as we proceed. There is food, refreshments, coffee, other beverages in the back, and then we also have restrooms over on the left-hand side if anybody needs them. And if there's anything else we can do to make you more comfortable, please let us know. My uncle John Carmon will speak second, and he lives here at our funeral home in Avon. He's a second-generation funeral director and the president of our company, Carmon Funeral Homes, which operates 8 funeral homes here in the Hartford and Tolland counties. We serve a lot of different families from all different ethnic backgrounds and faith backgrounds, and he also has the distinguished title of being a past president of the National Funeral Directors Association, which is the largest funeral directors association in the country. And he's traveled all over the country speaking. He's been on 2020. He's been interviewed by Barbara Walters, and he is a real wealth of knowledge in funeral service and pre-planning and all different aspects of what we do to care for families. Our first speaker is going to be Jay Kearns from Kearns Kearns in West Hartford. We are privileged to have Jay here with us today. We've worked together for many years. He helps a lot of families in planning, especially for elder care issues. He was the first certified elder care attorney here in the state of Connecticut. He travels all over the state helping people with elder care issues pertaining to Medicaid, wills, probates, trusts, and all different aspects of planning. And he has a wealth of experience. He has helped in writing and creating some of the laws pertaining to Medicaid, and he has been very influential in a lot of legal precedents that have been set regarding elder law here in the state of Connecticut. So without further ado, I'll welcome both of them. Again, if you want to hold your questions until the end, and if there's anything we can do, we'll be in the back to assist you. Thank you.
Hopefully you can hear me now. I feel like the Verizon guy. A lot of times people greet me with a familiar greeting that I'm sure all of you have heard, and that is, don't get old. But what we're going to talk about today is things that nobody likes to talk about and nobody likes to think about. Nobody likes to think about becoming disabled, dying, or death, yet it's going to happen to everybody here. But the message I have for you is 2 words, the Boy Scout motto, be prepared. And so how can you be prepared? One of the ways to be prepared is to have your house in order in terms of making sure that you have the appropriate legal documents and that you have your financial affairs in order. You've had conversations with your family. You've communicated what your wishes are. So first and foremost, in your folder, I have an outline of the ambitious topics that I'm hoping that we're going to cover this afternoon. And first and foremost, I want to talk about powers of attorney. How many people here have signed a power of attorney? Just about everybody. So everybody knows what it is, right? I hear a few nervous laughs. Maybe or maybe not. But in the state of Connecticut, a power of attorney handles financial matters. We did, once upon a time, have a power of attorney for health care. And if you signed a power of attorney for health care between the years October 1 in 1990 and October 1, 2007, then you might have had a power of attorney that was good for financial affairs and also health care decisions. But the legislature changed the law back in 2006, so effective October 1, 2007, if you sign a power of attorney after that date, it's strictly financial. And so we have somebody new called the healthcare representative. But let's talk a little bit further about powers of attorney before we talk about healthcare documents. First and foremost, if you're going to sign a power of attorney, you want to have a durable power of attorney. Now, frequently, people will look at the top of the power of attorney, and nowhere does it say durable. But in the back, it has these magic words. This power of attorney shall not be affected by my subsequent disability or incompetence or lapse of time. So what that means is the power of attorney is good if you're not. So first things first, you want to give somebody a power of attorney because you want to be in charge of your affairs and you are hand-picking the person who's going to be in charge. But more so, you want to have given someone a durable power of attorney so that they can manage your affairs if you are unable to do so. So if you've had a stroke, if you've been in a car accident, if you have contracted Alzheimer's disease, Parkinson's disease, I always tell my clients, bad things happen to good people. This way, you're ready. Now, aside from the durable power of attorney, what's a springing power of attorney? Does anybody know what a springing power of attorney is? Yes, ma'am. Close but not quite. A springing power of attorney is one that springs into effect upon an event which triggers it. So, for example, if you had signed a power of attorney for health care in the window of 1990 to 2007, that document takes effect when your doctor says that you're not competent to make medical decisions. So that's the springing power of attorney. And sometimes people have springing power of attorneys which say that the power of attorney is not effective until 2 doctors have certified that you are unable to manage your finances. So when we're talking about powers of attorney, it's very important to know the difference between a durable power of attorney, a springing power of attorney, the financial, the health care. We can have a general power of attorney where we can name all the different powers for different things that we would like you to do. Or we could have it limited where I hereby give you power of attorney to sell my car. So the one thing whenever you're drafting a power of attorney is think of it as your wish list. It's a list of the things that you want your agent to do on your behalf. So typically it's paying bills, it's handling your finances, your certificates of deposit, perhaps your stock portfolio. It might enable someone to sell your house if that's appropriate. So now let's talk about the healthcare documents. So the power of attorney is primarily for finances unless you had previously signed the power of attorney for healthcare. Now, first things first, a lot of times I'll be talking to clients and let's say, there's no way I'm going to the nursing home. I'm going to call Dr. Kevorkian. Well, now he's out of jail, and he's in Michigan. I don't know if he's going to travel to Connecticut. Or the second one is I'll join the Hemlock Society. There's no way I'm going to the nursing home. But seriously, everybody in the room should have what we call advance directives. And what an advance directive simply is, it's a document whereby you direct in advance what type of health care you want in the event that you are incapable and you cannot comprehend what your doctor is telling you, and you cannot communicate what your wishes are. So typically the living will would say, I, J. Kearns, hereby state that if I am incompetent and I am either in the final stages of a terminal illness, or if you pull me off the life supports, I'm a goner. It's irreversible, it's incurable. Or I am permanently unconscious. I don't know who I am, I don't know where I am, and I show no response to any stimulus, which means if you hit me with the rubber mallet, there's no reflexes. If you shine a light in my eye, the pupil doesn't dilate. Nobody's home. In that situation, I do not want the respirator. I do not want CPR. I don't want nutrition. I don't want hydration. But keep me comfortable. That's all that the living will says. Now, a lot of times people get confused and say, well, wait a second. Isn't that the same as a do not resuscitate? Well, no. The do not resuscitate is a medical directive that your doctor has to sign. The living will is simply a document that you sign which states that in the event nothing else can be done for you, that you do not wish to be kept alive through artificial life support systems. Now, in addition to the living will, prior to 2007, we had the power of attorney for health care, which means that the power of attorney could make any and all medical decisions, except the power of attorney for health care could not make decisions at the end of life. We had someone else called the health care agent authorized to make those type of decisions. So prior to 2007, the power of attorney for health care could make any and all health care decisions except at the end of life, and the health care agent then only made decisions at the end of life. So now, in 2006, the state legislature says we will merge the power of attorney for health care with the health care agent, and we'll now call that new person the health care representative, and they can make any and all health care decisions. See, a lot of the confusion arose out of the fact that if I name you in my power of attorney, you are called my agent. And if we have the health care agent document, then somebody's going to say, well, wait a second, if they're power of attorney underneath the power of attorney for health care, they're the agent, and they're also the health care agent. So there's a lot of confusion over those terms. And that's why the state legislature sought to combine those two different roles into one that's now called the health care representative, where now you're obligated to act in someone else's best interests. So all you have to do, if they're incompetent and we have to make decisions at the end of life about their treatment, you are required to act in their best interests and to make the decisions that you believe they would have made. Now, in addition to that, when we come to advanced directives, we sometimes, in the combined document, as I call it, it's one that you can find in the statutes, it's the living will, it's the health care representative in the same document, the designation of the conservator of the person. Now, most of us don't want to go to the probate court, particularly if we have to make decisions about pulling the plug or terminating life supports. But in the event that there's the family feud where some of the children don't get along with other children and they're not going to make a decision when it comes to pulling the plug, or the facility says no to the family, we will not honor mom or dad's wishes, your recourse is to go into the local probate court and have the probate court enter an order against the nursing home or the physician, directing them to abide by your wishes. So that's in the document as well. The last part of the document has to do with anatomical gifts. Now, as you know, I represent a lot of seniors, and sometimes my seniors tell me, hey, look, if the organs don't work for me, they're not going to work for somebody else. Forget about it. That's their personal preference. I'm not taking a position on that. Some people are very much interested in organ donations. Other people aren't. It's strictly up to the individual. But that's part of the combined document that you need to know about. Now, a lot of times people will say to me, I think I'm all set. I got a living will. And I'll say, I don't think so. Because the living will says, here's what you want. But ladies and gentlemen, who's going to enforce your wishes? The health care representative's going to enforce your wishes, so that's why you want to name people who will enforce your wishes. Okay, now the third document that everybody in the room needs, besides power of attorney and the health care documents, would be an up-to-date last will and testament. Now, frequently, I'll have somebody come into my office and they'll say, my wife Mary has Alzheimer's disease. She's got to go into the nursing home at a later date. And the first thing I'll say to them is, you need a new will. And they'll say, what do you mean? I just had a new will done a couple of years ago. It's up to date. It's fine. And I'll say, who's the beneficiary? Mary. That's why you need a new will. Because if you're not in the picture, all the assets are going to Mary, or should I say, Mary's convalescent home. So, just like in baseball, we have to keep our eye on the ball. You always have to take a look at the named beneficiaries in the documents. You also have to take a look at the named fiduciaries in the document. Fiducia in Latin means trust. A fiduciary is someone who stands in a position of trust, an executor, a trustee, or a guardian. If you have named someone in the document who might have suffered a stroke and is unable to manage their affairs, let alone yours in the future, for sure, you've got to update your documents. Because it's very foolish to be walking around with documents where you name someone as a beneficiary, someone as the executor to execute and carry out your wishes, or someone as a trustee in your documents if they are unable to do so. So that's one reason why you've always got to take a look at them. Second reason is, a lot of times we have people who come into our life and we have people that we're now on the outs with. Trying to say it in a nice way. But you know what I mean. And so you get mad at them, you want to take them out of the will, and you might put it off, but that's a good reason why you need to take a look at your documents from time to time. A lot of times in my office, I have people coming in, they've got the envelope, it's been sealed up for 30 years. You know what that tells me? They haven't read the darn thing in 30 years. And that's not smart, because you want to pull it out and you want to read it every 3 to 5 years to make sure it's current and it reflects your wishes. I can't tell you how many times I've had a situation where someone comes in, they have children that are now in their 50s, they made out the wills years before. Well, Uncle Harry is the named executor, and Uncle Harry now lives in Arizona. He's retired, and he might suffer from dementia, and there's no way Uncle Harry's going to be the executor. But you have a will that's 30 or 40 years old because nobody bothered to update it. And it still mentions a guardian for the kids who are now in their 50s, and it's still a trustee for the kids. And it might have Bank of Boston as the named executor, and we all know there's no more Bank of Boston. So for that reason, you really have to take a look at your documents at least every 3 years. My philosophy is, if it's not broken, we don't need to do a new will. But what I'm advising you to do is, just like with your IRA beneficiary designations, your 401k beneficiary designations, insurance policies, annuities, make sure that they're up to date with the named beneficiaries on them. Now, I'd like to talk to you about living trust for a few minutes. A lot of times people think that this is something that they need to have. It really depends upon your estate. It depends upon the size of the estate. It depends upon the assets that you own. For example, many years ago, I had a gentleman come to see me who said, "I'm worth $1 million and I need a trust." Well, I took a look at his assets, and he had an IRA that was worth $950,000. Did he need a trust? The answer is no. Why? Because the IRA is an asset that you designate named beneficiaries on. So he didn't need a trust because the IRA acted just like a trust. So before you go out and think that the trust is the next best thing to slice bread, or it's the magic bullet, you really have to take a look at the nature of your assets. So let's talk about trust for a second. What is a trust? A trust is primarily a contract. You know, if I execute a trust, I'm entering into a contract. And typically, there's 3 people to the contract. There's me as the grantor. I'm giving the assets to me over here as trustee who's going to manage the assets, and it's for the benefit of me over here as the beneficiary. So I can have the J. Kearns Trust. I can put J. Kearns' assets into the trust. I'm the trustee. And who's it for? Me. But if I became disabled, if I died, if I woke up one morning and say, I don't want to be the trustee anymore, I decline, then the document speaks and says, if J. Kearns can't be the trustee anymore, X is going to be the successor trustee. But an awful lot of times, I see people who will go to someone else and they'll do a trust, and they'll come in, and my first question to them is, what's in the trust? Why? Because the trust strategy doesn't work unless your assets are in the name of the trust. Here's the key to the trust concept. Everybody says that avoids probate. Well, how does it avoid probate? If J. Kearns takes all his assets and puts them into the name of the J. Kearns Trust, what does J. Kearns own? Nothing. Why? Because this thing over here called the trust owns all of my property. Now, who controls it? I do, because I'm the trustee, much like if we set up a corporation and had each one of you in the room as the president and sole shareholder of your corporation. I asked you, who's in charge of your corporation? You're going to say, well, of course I am. It's the same thing with the trust. Who's in charge? You are. But a lot of times people are thinking that this somehow avoids probate. It does not avoid the probate court fee. Under state law, upon your death, you do have to submit an estate tax return to the probate court within 6 months of the date of your death, and dependent upon the value of those assets, that's how the probate court sets the probate court fee. The real trick is, it may cost you more money up front to do the trust agreement, with the idea being there's less work for an attorney on the back end when you die, because everything's in the name of the trust and all we're doing is a tax return. Now, a couple reasons why people like to use a trust is, how many people here have heard of a will contest? Heard of people contesting wills? How many people here have ever heard of a trust contest? You've never heard of one because you can't do it in the state of Connecticut. So if you want to disinherit somebody, that's the way to do it. Now, when Jackie Onassis died, everybody remembers that you could read her will in People magazine. It was in the New York Times. It was even on the internet. But recently, when Michael Jackson died, he had a will that says, I, Michael Jackson, leave everything to his trust. Oh, sure, they had his will, but it didn't tell you anything, because he died with all of his assets in a trust. So another reason for using the trust is we avoid publicity. And so it's not a public document that somebody can go into the local probate court and say, gee, I'd like to see J. Kearns' file. I heard he died recently. I'd like to see what his will says. Well, the will is going to say, I, J. Kearns, leave everything to the J. Kearns Trust. There's nothing of any particular interest beyond that. So that's how the trust works. Last, because really we could talk about this all day, but I've got to leave room for John, and then we're going to take questions at the end. So save up your questions for the end. Last thing I want to talk about, Medicaid. Now, I am not talking about Medicare like the government cares for you. Most of you in this room knows that's not true. But we also know that Medicare is called Title 18 of the Social Security Act. And Medicaid is called what title of the Social Security Act? Title 19. So now you know where the name comes from. In the Social Security Act, Title 18 is Medicare, Title 19 is Medicaid. Aid, like to receive aid or assistance or an entitlement, is a welfare program. But why would I be talking about that? Because most of you know, or if you don't know, hang on to your seat, most of the nursing homes in the area now charge $400 a day or more. So that's $12,000 a month. That's nothing, right? No, that's $144,000 a year. And we haven't talked about those little bubble-packed pills. You know, we all go to CVS, we ask for the prescription, or Walgreens, Walmart, whatever, and you get a bottle of pills. When you're in the nursing home, all the pills are under lock and key. So they individually pack each pill on a piece of cardboard with saran wrap over it, and that's your medication. And it quadruples the cost. So that's always tacked on as an extra expense above and beyond the cost of the nursing home. But where am I going with this? Again, be prepared. Much like you want to have your legal documents in order in the event you became disabled or you died, you can't protect your life savings unless you know how Medicaid works. So first things first, in order to qualify for Medicaid, you're only allowed to keep $1,600 or less of assets if you're in the nursing home context. Now, there is a home care for elders program. I want to stay away from that because there's different waivers underneath the Medicaid program where there's different amounts of money that you can keep. And if you think you're confused now, if I went into that area, I'd completely lose everybody. So we're keeping it simple. So $1,600 is what you're allowed if you were in the nursing home. Now, if you have a spouse and the spouse lives in the house, much like the cat in the hat, the spouse gets to keep $109,560. That's the maximum amount for all 50 states. So if you're in Alaska, it's $109,560. If you're in Connecticut, it's $109,560. If you're in New Jersey, Texas, California, $109,560 is the maximum amount of liquid assets that you get to keep. So if you're the spouse in the house and your husband or your wife is in the convalescent home and they're in there for good, the three things you get to keep is, one, your home is your castle. They can't take it from you unless you go into the nursing home yourself. Your house is always protected. Why? There's no room for you at Jody Rell's house. Next, you get to keep $109,560. Why? Because does the state want 2 people on assistance or 1? They want 1. So the spouse in the house gets to keep a maximum of $109,560. Anything above that you must spend down. Now, there's something else that's confused a lot of people. We used to have a look-back rule where when you apply for Medicaid, the state looks back to see if you gave any gifts away. And it once upon a time was 2 years, then it became 2.5 years. It was 3 years until February 8, 2006. And on that day, President Bush changed the law to a 5-year look-back. Now, from today, if we went back 5 years, we're going back to 2005. But the law changed on February 8, 2006. So if we apply for Medicaid today, the state cannot go back further than February 8, 2006. Now, you cannot give gifts during the look-back period. So sometimes people will say to me, yeah, but Jay, I hear all the time I can give gifts of $13,000 per person. That's true. That's the gift tax law. Tax law is not Medicaid law. So you've got to be careful in terms of the gift giving. Because what the state does is they do penalize you on the transaction. Now, the state's not going to run after the people who receive the money. That's not what the state worker's job is. Their job is to determine, are you eligible or are you ineligible for Title 19? Their job is not to pursue the money. That's the job of the nursing home if you don't pay. Because the nursing home is much like a landlord-tenant relationship. If you sign a lease for an apartment, you have to give them a security deposit and you have to pay the monthly freight up front. It's the same way with the nursing home. They have no special claim to your assets. They're not like the Hoover vacuum where they're going to clean out your pockets. Well, they might eventually, but not up front. All right. I'm all set on the Medicaid. I will be back to answer some questions. And now I'm going to turn the program over to John.
We all you can hear me now. Leslie's just going to pass out some tickets because we did just want to express our appreciation for coming today. So I think at the end we're going to draw one of them, and I believe there's a gift certificate to Stop and Shop or Big Y, so that will be nice to be here at the end. And there is an evaluation sheet just so that you can write down whether we answered questions or whether we provided the information and did it in such a way that it was clear. I want to thank you for coming, and unlike Jay and my nephew, who you saw earlier, I'm a little more of a contemporary with many of you here. I've been a funeral director for 43 years, and so I kind of feel I'm maybe a little closer to one of you, and have gone through maybe some of the similar life experiences, and I'm at that point where I'm also dealing with some of those. With my wife's mom and in our own family, and some of the things that I'm now thinking about that I have to say, even though I was maybe a funeral director and involved in this, I wasn't thinking about it all that much when I was, in my 20s and 30s or 40s or 50s even. But anyway, I just wanted to tell you a cute story where you'll appreciate our kind of being in the same generation. I was at a meeting out of town last week, and as a little perk, we had a chance last Sunday to play in a benefit golf tournament. And it is an older group that plays in this, and I happen to be paired with a gentleman that was even quite a few years older than I. And he said, John, we've never had the chance to play before, but is your eyesight good? And I said, well, I wear glasses, Jim, but, my eyesight is good. He says, well, I really need to see someone, that can see where my ball goes. He said, I absolutely can't see it. And I said, oh, that's no problem. I can do that. So anyway, we got up on the first tee together, and actually my wife was playing with me, and his wife was playing with him. And he hit a very nice drive. It was around 200 yards. And for us, that's really great. And it looked like it appeared to be pretty much down the middle and everything else. And he said, did you see it? And I said, absolutely. So anyway, everybody had a chance to hit their ball. And we drove down, got halfway down to the thing, and I was riding with him. My wife was riding with his wife. And as we got closer down, we were halfway down to the fairway, and he said, so where is it? And I said, and he said, you said you saw it. And I said, yeah, I did, but I forgot. So, sometimes one thing goes and the other. So, anyway, I said, if we go back and maybe we redo it, maybe I can. Anyway, so again, I hope that you will take some notes, and then afterwards we can answer your questions. But further than that, I think most of you that know me too know that if you ever have a question, you can call me anytime, and we're glad to provide that information. We've been doing programs like this for many years. I have actually, again, about 40 years ago, the state used to do a program for their retiring employees. Any of you work for the state that were in that knew that? Would you? Then actually, Bill, I think of his last name, old friend. Anyway, who used to run that program for the state, I used to go all around 4 different locations, and if you were getting ready for retirement, they had a whole series of courses that you could take, and it was life planning for later years, and I did one of the programs on prearrangement, and we did it for quite a few years, and it was really a lot of fun. I met a lot of people. That was when the state had the resources to do that. So, again, maybe in the questions, but I'll just try to give you a little bit of an overview. There's really like 3 reasons why people sometimes will plan. And one of them is because they don't have anybody else to do it for them. Now, that may be that they may have family, but maybe their family is spread out now. We all don't live in these little communities anymore like before. Children move away. They're in different parts of the country for jobs or, living near where a spouse's family is. And so sometimes we feel like, we're kind of alone to do this. And there are people, we do serve a lot, that don't have children or maybe never married, and that, nieces and nephews might be the closest relatives, or maybe even none. So those people, it's very important that they do have some instructions done. There's another group, and that's people who have some very specific requests. And I smile because, over the years, I can share some stories about some very specific requests that would probably put a smile on all of your faces, too. But they're things that were very important to them. And like Jay said, too, sometimes there's family differences. And I met with a lady, I remember about a year ago, who said, I am doing this because my son won't do this. He won't do what I want to do. And she said, so I want to be sure that I am doing it. And sure enough, about 8 months later, she did pass away, and her son came in, and he did not want to do what his mother had wanted. And by the same token, it was a couple of months ago, a lady came in, and she just wanted to have everything in order. And she said, I know this may seem silly. I said, no, nothing is silly. I said, anything, if it's important to you, it's important. And she said, I take my friends to lunch at this particular restaurant, and we always have the same menu. And she said, it would be so important to me after my funeral if we could take my friends to this restaurant and have this special meal. I said, well, we can do that. That's what you want. We'll write it down. We'll set some money aside in the trust. I said, maybe, well, how many people are going to come? She said, oh, I know. I have a pretty good idea. So, even as specific as that was, and that was very, very important to her. And there are times, sometimes, people have things that they just want to be sure that's done. I know my mother, my dad died when he was 52, relatively suddenly of a heart attack and a heart condition. And, he and I were working together, but I was in my early 20s. My mother was in early 40s. I had a sister that was 12, and my two brothers were teenagers. And I remember even now, to this day, my mother's still 87, works every day with us still in the office. And she'll say, don't forget, there's a place for me next to Dad in the Veterans Cemetery. Mom, we know that, that. Remember, that is what we do. Well, I just don't want anybody to forget. That's very, very important. So sometimes it can be simple, sometimes not. And then there's another group or reason of people who just, and the common thread, too, is maybe being in control. You're in charge, but they want to be helpful. Maybe they just want to know what options and what choices that they have that maybe didn't exist 30 or 40 years ago. Or maybe, they've moved here. They're not from the area. Then there's some things that they would like to know about. What if I want to be brought back home? Or where is home? And, is that driven or flown? Or how does that all work? So sometimes it's just having a lot of questions and then wanting to be helpful. And it's important to be helpful because and I'll give you the disclaimer too, just because we're talking about this, and unlike a will, in which Jay talked about earlier, which is extremely important, if you don't make prearrangements, that's okay. Doesn't mean there's anything wrong. And sometimes in a couple that one feels strongly about it and another doesn't. I remember a few years ago where a good friend of mine, she kept calling me and saying, I really want to get together and we want to make arrangements, where my husband's retired now and we just have these ideas. We want to get everything down. I said, okay, and we made a time, and then she'd call and she canceled it. And we made a time and she called and canceled it. And then finally she called again and she said, well, we're definitely coming. Can we come tomorrow? Okay, come tomorrow, 10 o'clock. And she and her husband, I've known them for 40 years, and Bill came in, hi, how are you? And he was, hi, John, how are you? They sat down. She goes, oh, I am so glad that we're finally here and that we're able to make these decisions and have everything all done. And I looked at Bill, and he said, he said to his wife, "Speak for yourself." He said, "I'd rather be playing golf or anything else rather than this." And I said, "I can understand that." And she goes, "Well, I know, and that's been kind of the thing. He doesn't really want to do this, but I do." And sometimes that happens. So, don't worry. It doesn't mean that, that there's something wrong, because sometimes, one member of that couple or one half of that relationship, this is stuff that they need to have everything in order, and somebody else has the last thing that I want to talk about. And that's okay. And it can be any kinds of these arrangements can also be as simple in this regard as a husband and wife talking about it, or talking about it with your children and saying, I would like to do thus and so. Or, your mom and I have talked about this, or what we did, or I want to do the same thing that I did for mom, or for, and as long as that kind of communication oftentimes is made, that can be very significant. People also can at least sit down and write things down. I mean, you'll see there's a booklet in your things you can take back and actually make some notes and do some things. But it is a good idea, because there's no obligation and it costs nothing to sit down with one of us and at least find out all the things that are available today, what it is, what do we do, what are some of the things that you may want to do or may not want to do, and then even have that recorded and have it in a confidential place. And we're very glad to do that. That costs nothing. You don't have to pay for anything. And we have had circumstances where I will tell you that having that information available in our confidential files 24 hours a day, 365 days a year, has made a significant difference. A friend of mine he and his wife were traveling to Florida. He had a heart attack. They were on the Garden State Parkway in New Jersey. The ambulance took him to the hospital, and she stayed with the police cruiser and couldn't reach her son, who was traveling on business. She didn't know who else to call. She called us. We had, obviously, all the information that we could give the police, all the things we needed, and actually one of us drove down and picked her up on the Garden State with her car, and we were able to bring her to the hospital and then ultimately to bring her back home. And there's times had others and when people make prearrangements, we take the responsibility for them, which means that people don't always necessarily, we'd all like to think our time is going to be in our own bed, surrounded by all our family, everybody there with us. Well, the reality is that isn't necessarily what happens. Families live in different places. They're away, they're out, they're at school, they're somewhere else. And also sometimes we just don't know when that time is going to be. Had another situation where a man had actually died on a cruise ship, and he was alone. His wife had died 5-6 years earlier, and he just wanted to go out and have some fun, have a good time. They had some friends, but not really any close, and he just decided he was going to take this cruise, and it was an opportunity to meet other people. He died on the cruise ship. And, in his wallet had, in case of emergency, please call. Well, his daughter was away. She worked, she traveled, and she wasn't home. She also wasn't married. She didn't have any family. The police only got a answering machine. He did have arrangements with us, and he happened to carry that card that said, "My arrangements are on file with the Carmon Funeral Home." And we got a call from the ship's doctor, relayed at 2 o'clock in the morning, and we were able to tell them also he had another child who was a special needs child and lived in a group home. And not appropriately would that have been a good notification. And we were able to share that with the authorities and everything else, and then ultimately get the information, find the daughter, and help with that. So, and we do take the responsibility when that occurs to make all those arrangements wherever it is all over the world. And boy, do people travel today that never did before. We routinely bring people back or send people back for burial or their final disposition in about 7 or 8 different countries routinely. In fact, it's one of the reasons we do the web streaming here and at our place in Windsor, because we found there were so many families with connections and relatives that couldn't either get visas or couldn't come to services in a timely fashion. Okay. So there's good reasons why that this can be done, and it can be as simple as I said, talking to your spouse or your children, sitting down and writing something so that it's available. It's important that it be available either in the funeral home's file and or at least in yours, but you don't want to be putting these directions in a will. And Jay would tell you the same thing, because oftentimes that's a document not opened until long after those services are held. So if there are things that are specific, it's much better if those directions are outlined. Another little disclaimer, and I talked about you can't always pick the time. And sometimes what people have to remember, too, is that the circumstances, the manner of someone's death, a lot of those things are going to have and can have a different and a profound effect on their family. And I guess where we all would like to think that we want to make this as easy as we can for our children and for those that we leave behind, the reality is that our significant presence in their life is, it's the price of the love that we have. And people do need to mourn our deaths. They need to celebrate our lives, yes, but they need to go through that hard work of connecting with their family and their friends, and it just is the price of loving someone. And I've experienced it in my own family, and it's really not something. We always want to say, I want to make it easier. If people come in and say, well, and if anything happens, I want to be sure we do the service not at a time. All my grandkids go to college and they're here, and I don't want them to disturb them going to school or anything else. Well, the end of our life is a disruption, and it's really hard. And for the most part, it's very hard for anybody to concentrate that cares about people. They want to come together. They want to be with everyone as a family, and that's really important. Point being, no matter how much we plan, you're planning to make the details easier for your family. But please don't think that planning will take away, the hurt and the mourning and the heart that they need to do. That's really important. As a matter of fact, it can make it easier for them, because if they don't have to worry about some of the detail issues, they can concentrate on some of the things that are important and important to them, and doing some things that are significant. And it's like being too dictatorial. I had a lady leave instructions for her 3 sons, all of whom were attorneys, and one from Washington and 2 from this area. And she left instructions. She said, I do not want an obituary. So when they came in and we made the arrangements and everything else, and they arranged for the funeral, they said, well, we're going to call everybody and everything because Mom said, I don't want an obituary. And I said, okay, did that mean that she didn't want you to publish something in the paper that said, J. Carmon died at such and such a time, and the services are going to be, and this is who they left? Was that what she meant, or did... And they said, well, yeah, I guess so, but isn't that an obituary? And I said, well, it can be. But I said, an obituary, you're attorneys. I said, I consider an obituary sometimes more like a spiritual will. And it can have really significance for some family members. Would you like to tell the grandchildren and the great-grandchildren and have something written, for generations to see about, and would your mom, about the values and some of the things that her life had meant to you and the ones behind? They went, oh, I didn't think about that. Well, and I said, well, maybe she didn't. But we don't have to publish that. We can do that in kind of this form for you as a family so that you can share that. Would that be okay? Oh, well, we probably didn't know we could do something like that. I said, well, I know. That's kind of why we're here. And that I'm just trying to give you the benefit of, 42 years of experience, and that sometimes those things can really be meaningful for even grandchildren or great-grandchildren, that they may want to, why don't we have everybody weigh in on this? Well, ultimately they did that. It ended up to be a very meaningful thing for the family. We ended up doing it in obituary format so that they could each have one for their homes and everything to keep. And then 2 weeks afterwards, they called up and said, we think we'd like to publish it in the paper too. And we know that wasn't maybe what our mom wanted, but we don't ever think that we think she would have been so happy to know that these were the values that she had communicated to us. And that's what that meant. And that her life really was significant. I mean, and she was trying to make it easier for her kids. And I'll give you a personal story about that. Sometimes people will say that to me. Don't you want to do that? Don't you want to make it it easier for your kids? And I said, well, let's see. I had 4 sons who, as teenagers, when they were teenagers all at the same time, pressed every envelope in the world. They did not make my life easy while they grew up. And I said, quite honestly, I was even thinking, because I want them to carry me to the cemetery, of even putting some bricks in that casket to make it a little heavier so that they knew that they were doing. And then smiled and said, I don't mean that, yes. I do, you want to make things easier for children, but I don't want to take away some of the things that they may need to do. And it's like children taking care of, as a generation sometimes. We do so much, our parents did so much for us, and we took them to this, took them to sports, did this, sacrificed so that they could go to school and that they could, get an education and everything else. And then, if we get sick, we don't want to call them to inconvenience them. Well, sometimes they may just want to. And that this is their way of kind of paying that back, and it's like give them the opportunity. The other day, we got word, my daughter-in-law, one of my sons is a Border Patrol agent in Arizona, and he has 3 little girls, 6-month-old to 8 years old, and they were in a serious car accident with my daughter-in-law. Called for the helicopter. The car was destroyed. They thought that, of the worst, and turned out the car seat saved my 3 little granddaughters. They didn't have a scratch. They were fine. My daughter-in-law, they had to pull a car apart to get her out, and she had surgery yesterday, but only ended up with a broken foot. Thank the Lord, was very, very good. And my wife is going down there tomorrow, and but same thing. My son said, well, we're all right. We'll take care of it, and I've got some time off, and we got some neighbors and everything else. Well, no, you're kidding, my wife? I'm going. I'll be there tomorrow. How long do you want me to stay? 3 weeks, a month? And she just said to me, give me a check, and I'll let you know when I come back. And I'm sure you'll be fine. You can get food somewhere, and you'll learn to use the washing machine. So, parents will do anything, anything for their kids, and it's nice sometimes to give the kids the opportunity to give back too. So, again, we can't always dictate everything. And sometimes, we've got opportunities to do things to be helpful, and if there's specific requirements and things. Jay talked about Title 19, and sometimes it becomes an absolute necessity to prepay one's expenses. And this is the last topic I'll talk about, because I think it's important that you know, if you do that in the state of Connecticut, what protections that you have. I helped write the laws that allow this back in the early 80s, and I was familiar with laws all over the United States and how some states it was not good. And many of you have probably read AARP articles that say do not prepay for your funeral expenses. And in some states, I wouldn't prepay either if I lived there. And some, there are more plans, and that they're also more. It's like selling a plan as opposed to it is making your arrangements and then having a safe way to fund it. And then if you moved, you may not get it back, or there's all these things. I'm just here to tell you, and there was an article, one of the probate judges, I think Judge Killian that wrote, and said, you know, in Connecticut, you should know that you have some safety after there was a piece that was in the paper. But just as a highlight, for Title 19, you are allowed to prepay your funeral expenses for an irrevocable service trust and what's called burial space items under a definition that's under federal Medicaid laws, so that basically whatever someone wants to do, they can cover and pay for their own arrangements. And sometimes that's extremely important. You know, sometimes, again, kids will say, well, I'm going to take care of that for mom and dad, so we don't need to do that. Well, sometimes people want the dignity of taking care of it themselves and knowing that they did. They don't want their kids to do that, and that part, and certainly that is available to them. But if you do, I put this up here so that I'd write, but may be hard for people to see. I'm just going to put a couple of things so that you know, if you prepay or give a funeral home money that for funeral arrangements, that 100% of the money must go in trust. 100%, all of it. No, in some states that's not true. 80-20, some they keep 20%, they put 80% in trust, or other. Connecticut, it's 100%. 100%. You also, it is also completely, it has to be invested in either insured accounts, i.e. it's in a bank account, or it's got to be in government bonds or any instruments that are backed by the full faith of the government. It's not an investment that maybe is going to go off the charts in earnings. Of course, there hasn't been too many of those over the past few years, actually, other than these trusts, ironically. But we use a government bond fund through our state association. We, even after, and they're all what's called now QFTs, or Qualified Funeral Trusts under IRS guidelines, so that we can have them pay a small amount of income tax directly out of the trust, and you don't have to be involved in K-1s or what's the other tax form? 1099s, right. And so, in fact, our trusts have earned somewhere between 3.8% and 4% over the last few years. That which is used to defray inflation and cover those costs in the future, which I'll get to. So the money has to be invested safely. It cannot be in something that's going to lose principal. 100% of it has to be in trust. There is an outside escrow agent. So in other words, the funeral home is not holding the funds. They have the obligation to provide for you what it is, but they can't be that escrow agent. It must be outside. In our case, we use a company since 1985, Access Financial in Chicago, who's a registered broker-dealer in Connecticut. And they also, so that if I was out of business or family wanted to contact them for any reason, they can go directly to them. It is also completely transferable or portable. Completely. Now, transfer means somebody says, you know, and we have this happen quite often. Family came in a few weeks ago here, and they had lived in Stamford all their life. They wanted to move up here closer to their children, and moved into Farmington Woods. And they said, you know, we're here, but we had made these arrangements with the XYZ funeral home. That's fine. We contacted them, sent them a letter. They transferred it all up to ours. It was completely transferable. Portable meaning that, you know, somebody wants all of a sudden, may make all their arrangements and they do something and, well, decide, I'm going to retire to Arizona. I just can't stand the winters up here. And again, it's completely portable. They get annual statements. They must get annual statements. And a confirmation that those funds have been placed in trust, not just by the funeral home who does it, but by the outside escrow agent. So, 100% of the money goes in trust. It must be invested in safe instruments, anything that would, you know, not anything, no gold, no stocks, nothing that has the potential of losing losing principal. There's an outside agent that is responsible. It's, it can be transferred. It's portable. You get an annual statement. Trying to think of any of the other. Individual funeral homes may have some provisions that are, better than others. Obviously, are there guarantee provisions? If you have this somewhere, is it guaranteed? In other words, if this happens 10 years down the road and you've paid for it, is that guaranteed? Is all of it guaranteed? Are the outside expenses, typically cash disbursements, outside expenses like obituaries or maybe fees for clergy or those kinds of things, oftentimes are not guaranteed because they're not under the purview of the funeral home, but they can be. So it's really important that that's all very, very, very clear. The state statute does say that if a trust is transferred or taken somewhere else or canceled if you have a completely revocable trust, and taken all back, that the funeral home who did issue that could charge an administrative fee. There are many of us that don't have any, and you want to be sure that's clear. It could be up to 5% of the value of the trust, or none. And it's no different than like closing maybe a long-term account out early or something else, because actually the funeral home has received no compensation for anything they've done or even the maintenance of the trust. But in all the years that we've done these, I could count on one hand the number of times that people had transferred them, and it was because they moved to their retirement home in Vermont or somewhere else, and it just wasn't convenient, and we gave them every nickel and transferred it. So we said, well, we're not going to follow that provision, which we can, and there's no transfer fees. So that's just a highlight. Obviously, every situation is specific, as Jay said, and we'd be glad to answer questions on that. I think the important thing is, I think anyone, especially when we're invited into people's hearts at the worst time in their lives, it's something that we take very, very seriously. And as I'm sure that Jay does, anybody that's involved with your personal issues, whether it's finance or your personal things, or in this case, certainly the emotions and the difficult time you go through, it's really, just really important to us. And I always look at it kind of like there's a story that I heard on a sign-off on radio one night, and it was a rabbi telling about someone coming into a strange city, and he was on a bus, and he got off the bus, and it was pouring rain, and it was cold. And when he got off the bus, he didn't know where he was going, but he knew the name of the hotel or whatever that he was checking into. And he asked directions. And the first person said, well, you just go down 2 blocks and take a right and then take a left, and you'll find where you're going, right down there. He said, okay. So, but again, it's a strange city, and he tried to follow the directions, and halfway through, he was lost. And he, just bewildered again, and it was wet, and it was cold, and he came upon someone else on the street, and he said, I'm trying to find such and such an address, and I had directions, but, I'm just confused. And that person said, well, come with me. And they took their coat, and they put it over him because they could see that he was cold and wasn't prepared, and had a large umbrella, and he carried the umbrella, and he took them to that hotel. Well, the first person was fine, certainly didn't walk away or shun him. He gave him directions. But that second person just, they took care of him. They just put their arm around him and said, come with me, and I'm going to take you to where you're going. And I'd certainly like to think that that's what we do, and that really what any funeral home should do, because this is a very, very difficult time, and you should feel that that you just have someone that is going to help you, help your family, and someone, no matter what the circumstances or what the needs are, that they're going to walk through you with that. So with that, thank you very much for my part. I hope I didn't take too much time. Jay, questions? The
HIPAA waiver.
Oh, okay. Is that yours?
The HIPAA waiver is a federal law that says that your medical records are held private, confidential, and no one else has access to doctor to present your bill to the insurance company, they need you to sign that HIPAA waiver. But if your relatives were named in the healthcare documents to be in charge of your medical decisions, they might want to get a second opinion, and they can't unless you had signed a HIPAA waiver. So one of the things that our office does in all the healthcare documents is put a HIPAA waiver in the stock of your healthcare documents so that your family is authorized to access that information. So it's very important that you do in fact give people a HIPAA waiver so that you don't have a hospital or physician saying to your son or daughter, gee, I'm sorry, we can't give you the medical information because dad had never signed a HIPAA waiver.
And if everybody, that HIPAA has been so difficult. I don't know if everybody's so familiar with that, but years ago, it's like clergy from a community, would go down and they would check a list in the hospital and see who was there from Avon, and then they would go visit, and something may happen, and they would stop in. They can't do that now. They won't even tell them. If you're not invited to go, the hospital's not obligated to even give them that information. I mean, it's so, it's one of those balances in the law.
Right. Yes, ma'am. The question is, does Connecticut recognize wills or directives from other states? The answer is yes. We even have an International Wills Act in the state of Connecticut. So if you did one in Ireland, it's good here. But one of the things you always have to prove is that it was validly executed in that other state. So when it comes to the advanced directives, underneath the law that changed back in 2006, either the hospital or the doctor have to go research to make sure that you have the appropriate document under California law if you're going to present that in Connecticut, or the agent that you name certifies in an affidavit that in fact that document was properly executed in another state. But one of my favorite sayings is, in Rome, you do as the Romans do. So to avoid the red tape, if you are coming here from another state and you are going to become a permanent resident here in the state of Connecticut, Connecticutize the documents. Yes, sir. I discourage people from naming an attorney. If somebody wants to name me, that's usually A, a last resort, or B, the sign of a dysfunctional family, where nobody gets along, and I'm the guy with the black and white striped shirt, the yellow flag, and the whistle. And my job is to call fouls on people. And that's not a comfortable position sometimes, but I'm willing to do it if that's what the client wants. But it's not something I'm readily willing or wanting to do. And if you run across a situation where an attorney wants to name themselves in your documents, it's kind of like approaching the railroad crossing. You got to stop, look, and listen. Yep. Yes. The question is, the way I understand it, if I was to die tomorrow, there's no way to protect my assets. I'm not sure who you're protecting your assets from. Well, if you die tomorrow, then we're not really worried, right? All right? But, well, one of the things that I use a lot in my practice is I try to encourage people to plan ahead, because you now are going to have that 5-year look back where you can't give away anything during the 5 years. Right. Well, if you're going to a nursing home a year from now, unless you have long-term care insurance, or B, you have no money, you have no worries. And so the idea is you've got to plan ahead because of this law. I mean, we all want to be in control of our property. It's called our life savings. We want to hang on to the purse strings until the bitter end. And one of the things I tell clients is you really have 3 choices. Choice number 1 is we do nothing. So it's like putting your head in the sand like an ostrich. Doesn't accomplish anything. But a lot of people engage in avoidance, denial, or procrastination. Well, Mom's not getting old. Oh, we're not going to worry about it. Mom's getting forgetful and she's got a lot of dings in the car. We're not going to take away the keys. Everybody waits for the perfect moment. And all John has tried to say it, and I'm saying it too. There is no perfect moment in life. And so you've got to plan ahead. So number one is you do nothing. Two is if you put it into the kids' names, are there creditors or predators going to grab it? Are they going to get a divorce where the outlaw now owns half your house? Or are they going to have a creditor situation where they're overextended on a mortgage, they lose their job, they get sued, they hit somebody with the car, and because they're in a car accident, somebody's suing them now and looking for their assets. Number three is, one of my favorite strategies is using a living trust. And there's a variety of different living trusts that you can use for different purposes. One is avoiding probate. My favorite is to avoid probate and insulate the assets so that you do not have control over them so that they're inaccessible from Title 19. But there's different strokes for different folks, and it's not like the widget where one size fits all. Yes, sir.
I've had discussions with retirement communities and convalescent homes that say we're not for profit or we are for profit. And I ran into one situation where one of those that was for profit, people came in and had signed up, and then that corporation that owned the place went bankrupt. What then happens to the people that are in, where they sign their money over?
I think you're talking about continuing care retirement communities.
Yes.
We call them CRECs. That would be a Doncaster, Macaulay, Simsbury. In those type of situations, they give you a prospectus before you go in the door. It's a very lengthy contract that's required underneath the state banking commission rules that they have to give someone. It's almost like buying a security. And in it, they talk about the finances because that was a big problem back in the late 60s, early 70s, when quite a few of these facilities, especially down south, did in fact go bankrupt. And it's kind of like the buyer beware, and that is if you shell out a large down payment and then you're obligated to the monthly payment schedule and the facility went bust, you might have a problem. There's really no way to protect yourself against that situation other than do your due diligence.
This for-profit, non-profit?
No, not in my mind. Was for-profit or non-profit, if you're going in there with your life savings and you're going to put down $200,000 or $300,000 to buy the right to use a unit, and then you're going to pay a monthly fee of, let's say, $4,000 a month, with the idea being it's $4,000 a month for the apartment, or if you're in the nursing home bed, it's $4,000 a month because of that large fee that you put down, the entrance fee. You've got to be very careful. Yep. Yes. Well, you have your choice. Sometimes the living trust isn't for everybody because people feel like they have handcuffs on or they're in a straitjacket where it's my money, but I can't get to it because I have to make it inaccessible for the nursing home and also Department of Social Services. One of your options might be to take a look at long-term care insurance. So what I'm saying in a nice way is, again, different strokes for different folks, and I would have you look at those two options. What would it cost me for a long-term care insurance policy for a different amount per day for a different number of years? There's also the Connecticut Partnership Program where you can insure yourself to the amount of assets that you own, where the idea being if you, in fact, access the long-term care policy and use up all the money underneath the policy, you then go on to Title 19 and you get to keep all the assets that you own in your own name. That's how the partnership program works. But those are two of your choices, and I'd have you take a look at that.
That gentleman had been. Do you have that? Do you have a question, sir?
The man in the blue shirt?
Yes. Oh, okay.
Okay. Yes, ma'am.
I have mine. Okay. Well, we own our own crematory, so we operate our own crematory so that when we care for someone that's the disposition that they want, they never leave our care. Also, the crematory is a facility no different than a cemetery. It is the place of final disposition. The cemetery is not licensed by the state of Connecticut or in any way prepared to come and make that transfer from wherever the place of death is. Also, the filing of the death certificate, the cremation papers, and the authorizations and everything else. So for whatever extent that someone wants, the cremation and or whatever other services may be outside and incidental to that, the funeral home can play a major role. Plus benefits. We do so much today with obviously helping the family make transitions with Social Security, also veterans benefits, which are constantly changing. Jade, I didn't hear you touch on that new aid and assistance benefit from the Veterans Administration. But there's some things today that are that have come in because of the age of World War II veterans and things that the government has really stepped up to do a lot to help, and they can be considerable. As a matter of fact, that aid and assistance benefit could actually keep someone off Title 19 for a length of time. You may want to just mention about that.
Okay. Why don't I talk about the aid and attendance benefit first? For veterans, there is a non-service connected disability program. It's called AID in attendance. To qualify, you must have served in a declared war for at least 1 day. 2, you must have been in the service for 90 days. 3, you must have received an honorable discharge. Now, recently there was an article in the Wall Street Journal about the program within the last, I would say, 45 or 60 days. The article was wrong because it said that you have to get your assets below $80,000 in order to be eligible for the program. That's partially correct. Over the last year, the Veterans Administration now looks at life expectancy tables to determine whether or not you're going to outlive your assets. But it's primarily based upon income, where the Veterans Administration takes a look at your recurring medical expenses, not hypothetical ones, not ones in the future, the recurring ones now. In terms of assisted living, if you're in an assisted living facility, you're deemed to be disabled. And if you're paying $6,000 a month for the assisted living facility, that's a recurring medical expense, which is higher than perhaps your pension and your Social Security. And if that's the case, and your assets are in fact down below $80,000, there's an excellent chance you're going to qualify for the program.
Veteran or widow, too.
It's also good for a widow who was married to a veteran, not divorced, married to the veteran. When the veteran died, the widow is entitled up to $1,056 a month. Now, the only time you lose the VA benefit is if you apply for Medicaid and Medicaid is granted. At such time as you receive Medicaid, you must notify the VA to shut off the VA payment. Otherwise, they will pursue you for what's called overpayment, because you can't dip into both pockets of the government. Sure.
benefits are retroactive to the date of application, however, so that they are fair because they can't deal with it. And I would say that some of it can be very complicated, and those forms, you really are wise to have legal help to do it. It really is worth it.
Yeah, I would just make another comment on that, and that is, you know, when you apply for Medicaid, it's almost like dealing with the Nazis in terms of they don't believe you, they think that you're lying and that you're trying to pull something over them. When you apply to the VA, they go out of their way to help you. And it's not been my experience that they are there to disqualify you. I've seen clients do things that aren't that smart, whereby they will be applying when they're selling a house, and then what happens is during the pendency of the application, the house gets sold, they get the cash, now they've got over the $80,000, so of course they're not going to qualify. But it's things like that that sometimes happen which prevent somebody from qualifying for the benefit. But it's been my experience in working with several clients where if you really work hard at preparing the application like you're presenting it to a fourth grader, and you line everything up with all the attachments so that you're proving your case with all the receipts, I've had them granted within a 2-month window. I've had other people come into my office complaining that it's taken them 11 months. And I'll tell them, you can't presume anything here. You know, you have to lay everything out. You know, you have to have the 1-year prescription printout from CVS or Walgreens, divide it by 12 and say, that's the average cost of my prescriptions. You can see it right here. Here's the bill from the assisted living facility and a letter from the assisted living facility saying, Mr. Smith has been a patient here since the last year, and here's the monthly costs. And this way you lay it out for him. And I find that when you do that, the application's greatly expedited. Way in the back. No, that's not correct. The veterans benefit is treated as if it was a pension that was paid to you. And it's not a gift. You're not obligated to pay it back. The only time you're obligated to pay it back is at such time as you qualify for Medicaid. You must stop it. You cannot receive the VA benefit and also receive Medicaid at the same time. Ma'am, in the back. The question is, if I've executed a healthcare representative form, in addition to that, do I need the HIPAA waiver? The answer is yes. The HIPAA waiver is federal law. And the federal government has said that your medical records are protected unless and until you sign in writing a waiver waiving the privilege. So it's only you that can sign that waiver. So in our practice, I incorporate that into what I call the combined document, which is the living will, first paragraph, second paragraph, the appointment of the healthcare representative. My third paragraph is the HIPAA waiver. Fourth paragraph is the designation of the conservator of the person. And then fifth, at the option of the client, is do we have the anatomical gifts or not? HIPAA. It stands for Health Insurance Portability Accounting Act of 1996, and it took effect on April 1, 2004. Yes, sir. During that window. Yes. Correct. Yes, ma'am. Well, my experience is, you know, on some things it's great to do it yourself, such as going to Staples or Home Depot or Lowe's. But when it comes to a power of attorney, if you do it wrong and the person's no longer able to sign a new one, they're stuck with what's in the four corners of the documents. And I have had people come into my office where it doesn't have the proper number of witnesses, and under Connecticut law it's 2, or the notary has signed where you are supposed to sign. I've had that happen before where the client walked in and said, here's my power of attorney. Her signature wasn't even on it. The notary had signed twice, once where her signature line was, and then signing again as the notary. And so my advice is, this is something you want to do it the right way, and you want to do it one time. Now, a lot of times people will say, well, I'll just get it off the internet. I'll just go get the Connecticut power of attorney. Well, I have 5 additional pages of powers on mine, because in the Connecticut power of attorney, you're not authorized to sign income tax returns. And guess what? If you sign the IRS power of attorney, it's good for 3 years, and then it expires unless you renew it. So there's a lot of these type of powers, such as giving gifts. If we're talking about protecting assets, I think you want to authorize your agent to give gifts, if it's possible, during the 5-year period. There's that type of stuff that's not in the Connecticut power of attorney that you might get on the internet or out of the statute book. Yes. Mm-hmm.
Mm-hmm. No. We have common forms that we've used that are all approved by the state and everything that are fine. You don't incur any expense to set that up or maintain it.
Yes, ma'am. To the best of my knowledge, there's only one state that has reciprocity with the state of Connecticut, and that's Indiana. Once upon a time in 1988, the state of Connecticut got money from the Robert Wood Johnson Foundation. You may have heard of Johnson & Johnson. But the Robert Wood Johnson Foundation gave money to the state of Connecticut to explore the use of implementing long-term care in partnership with the state and the welfare agencies, state and federal. And Connecticut was the first one to implement the partnership program. New York State was second, California was third, Oregon was fourth, Indiana was fifth, and then Bill Clinton signed a law in 1993 prohibiting any other states from enacting partnership programs. Well, part of the Deficit Reduction Act, which changed the 3 years to 5 years, that's how it's going to reduce the deficit, changed the law so that now all 50 states can now have partnership programs. Being a futurist and looking out in the future, I think it's just a matter of time before Connecticut starts having reciprocal agreements with other states besides Indiana. I haven't seen a lot of clients wanting to go to retire to Indiana. Right now, nobody else does it. But I do believe that's a trend that you will see be reversed in the future. Yes, ma'am. I didn't say anything about natural burials.
You're talking about green burials? Okay. And by green burials, we'd have to comply with whatever regulation that there might be in a cemetery, whether they required a permanent outside container or whether we could turn that upside down so that the casket or container could be on the earth. I mean, there's ways that it can be done if that's what you're referring to. I'm familiar with Pennsylvania. Actually, we had a service here and brought someone to Pennsylvania, and we buried them on their own property. And in Pennsylvania, they don't have any statutes at all, other than if you're within an individual municipality. You'd have difficulty doing it in Philadelphia, say, so to speak. But out in a rural farm, there aren't any regulations. In Connecticut, you would either have to have specific zoning approval by a community, or you'd have to be in a designated cemetery. It's a possibility. It's something we'd have to pursue. Now, that's a full burial. If it were to be someone's cremated remains, that's a different issue. And as long as they weren't in a permanent container, there's some other things. So, but it's an individual circumstance. I'd be glad to answer that.
We're going to take 2 more questions, and then I just have 2 announcements. Sir? They don't honor them. That's usually something that the securities firms require. Under Connecticut law, power of attorney is good until such time as A, you die, power of attorney dies with you, B, you revoke it, you fire the agent, or C, you have a conservator of the estate named for you by the probate court. So I run into this scenario all the time where my trick is I use gold seals. Don't tell anybody that. But the gold seal looks like it's from the king or from the court. And so when my clients go walking in with that power of attorney with a gold seal on, the banks never seem to have any questions. And if they do, the clients are trained to call my office where the receptionist has a letter on the word processor called counsel's opinion letter. And the counsel's opinion letter says, to whom it may concern, I, J. Kearns, executed John's power of attorney on this date. To the best of my knowledge and belief, he has never revoked it. He's still alive. Either he's competent or he's not. And under Connecticut law, the power of attorney is still in full force and effect. Call me if you have questions. And I'm like the Maytag repairman. My phone never rings on that issue. You can get them at Staples. You just put the notary seal right through it. All right. One last question.
Okay. The question is about really authorizing cremation. We are a next of kin state, which is kind of important for a lot of things, meaning that your next of kin is the entity that would direct disposition or anything else. It's kind of important. But we also have the ability that someone can authorize their own cremation. They changed the forms a few years ago. But, you know, our legislature always puts the little caveats in, too. So you have to name first 2, you know, you have to have 2 witnesses to that, which we can take care of very easily. Then you have to have a designated person that we just have to double check with to make sure that that, in fact, is okay after the fact. But you can sign your own. If it's after death and it has not been signed, that's okay. Your next of kin can do that. We and most cremation authorities will accept the next of kin or the one that's designated. There are some states, if you were in, say, California, and there were 5 children and no spouse, they would require the signature of all 5 of those children because they're of equal kinship and they all have the same right. We don't get that technical here, unless there was an issue of, you know, it was contested, then that would put up the red flags. But
right, that's one point I want to dwell on for a second, and that is, in my early experience, I've had families who are dysfunctional when it comes to time to the funeral, whether it's going to be a cremation, it's going to be a burial, whether or not the gentleman's going to be buried with their uniform on from the service or the governor's foot guard. And one of the things that we do is we instruct the client to go to the undertaker that they would use and sit down with them and make sure that their wishes are in writing, because that way they trump anybody in the family that wants to undermine their wishes. You know, people get crazy when somebody has passed away. And, for that reason, you want to plan in advance to make sure that whatever your wishes are come true.
Especially with all the day we are in of blended families with, multiple marriages and, his children, my children, their children, and all the people that sometimes can be involved. I mean, we were involved in a situation just very, very recently about the new spouse of 25 years did not want to bury her husband with his first wife. And they had purchased a lot together and everything else, but all the children of the first spouse thought Dad belonged back with Mom, and it was really very clear, and they had done this together. And I said to the children, I said, beside that, your stepmom is in charge. I mean, she is. But had something happened to her, and she wasn't, we would have had two sets of children now trying to make these decisions. And like Jay said, in the absence of writing, it sometimes gets, it can be very, very interesting.
It's a tug of war over the corpse. All right, two announcements are, number one, you have surveys, and in order to enter the raffle, you must give Frank or Leslie your survey so that they can take your raffle ticket for the raffle drawing. And number two is, I'd really like to thank John Carmon, Frank Carmon, the Carmon family, and the employees here who spent a lot of time and energy putting together this great public service. And I'd like you to join me in a round of applause for John and Frank for a great job.
Thanks. Frank, do you have, do they have those evaluations? You do. They're in the folders?